Welcome back to the deep dive. Today, we are wading into some truly murky waters. We spend so much time in criminal law focusing on, the person holding the smoking gun, the one who actually pulls the trigger. But what about the person standing next to them? Or the
Exactly.
person who bought the gun? Or just drove the car and kept the engine running?
Right. We are shifting gears from individual liability to, well, group liability. This is Module 6, parties to crime. And the central question we're tackling is, how does the law hold one person responsible for the criminal acts of another?
It sounds so simple on the
It
surface.
does. You helped, so you're guilty. But as we're about to see, the legal mechanics of helping are incredibly complex.
It's the difference between actually doing the crime and just facilitating it.
Yeah.
So what is our mission for this deep dive? How are we going to break this down?
We have a very specific analytical path to follow. First, we need to clear up the who's who.
Hmm.
We'll look at the difference between principles and accessories, and a really tricky concept called the innocent agent doctrine. Second, we will dissect the actus reus of accomplice liability, what acts actually count. We'll look at presence, omissions, and causation. Third, we have to look at the mens rea, the mental state. And that's where we run into the whole double-barreled crime dilemma.
And finally,
And finally, I want to leave you with a diagnostic checklist you can actually use to spot these issues on an exam.
okay, let's unpack this. I want to start with that first point because it trips people up immediately. We think principal is the boss and accessory is the helper. But the law has a very specific way of defining these roles, especially when someone uses another person as, like, a tool.
Right. And this is the innocent agent doctrine. Before we even get to accomplices, we have to identify the principal in the first degree. Usually that's the person who performs the criminal act, the one who shoots the gun, steals the wallet.
But what if I don't touch the gun? What if I trick a child into doing it?
That's the pivot point. If you use an innocent agent, someone who lacks criminal capacity, like a young child, a mentally incompetent person, or someone you've tricked who doesn't even know they're committing a crime, you are the principal in the first degree.
So if I hand a poisoned apple to a 5-year-old and say, go give this to Snow White, and the child does it, the child isn't the murderer. I am, even if I'm miles away.
Precisely. You are the hand behind the act. You aren't helping the child. You are committing the crime through the child.
The child is just a tool.
Just a tool, like a long stick. And that distinction is vital because if you spot an innocent agent scenario, you don't even use accomplice liability rules. You just charge the manipulator as the principal.
Got it. So assuming we aren't using innocent agents, assuming we have two capable adults working together, now we get into the common law categories. I know the common law loved its labels. What's the difference between a principal in the second degree and an accessory before the fact?
It really all comes down to one word: presence.
Presence.
The general rule is this: a principal in the second degree is someone who is present at the commission of the crime and aids, counsels, commands, or encourages the principal. An accessory before the fact is someone who aids, counsels, or encourages, but is not present when the crime actually goes down.
So the key distinction is just showing up.
Physically, yes, for the most part.
Yeah.
If you are there, you're a principal in the second degree.
And if you're not.
If you helped plan it, bought the masks, drew the map, but stayed home to watch TV, you're an accessory before the fact.
But knowing the law, presence is never that simple. If I'm the lookout down the street, I'm technically not present in the bank itself. Does that let me off the hook from being a principal?
You know it doesn't.
Yeah.
And this brings us to the sub-rule of constructive presence. You are constructively present if you are physically absent from the immediate scene, but you are aiding and abetting from a distance at the time of the offense.
The lookout.
The lookout is the classic example. They aren't in the vault, but they are on the job. The legal test is, do they have the ability and the design to render aid if needed?
Ability and design to render aid. That sounds logical for a lookout, but let's test the elasticity of that definition. We have a case in the stack, Sutton v. Commonwealth, that seems to stretch constructive presence to its absolute breaking point.
Oh, Sutton is a disturbing and, frankly, controversial case. It really pushes the limits of what it means to be present.
Okay, let's analyze Sutton v. Commonwealth. To set the stage, what are the legally dispositive facts?
So you have a young girl, she's living with her aunt and uncle. And over a period of time, she was coerced into sexual intercourse with the uncle. The aunt played a significant, just horrific role in this coercion, creating this atmosphere of fear and dominance over her niece.
Okay.
However, and this is the key for our analysis, at the precise time the specific rape charge occurred, the aunt was not in the room. She was in her own bed in another room, possibly asleep.
That is a nightmare scenario. But strictly from a legal perspective, the issue is whether the aunt could be considered present, either actually or constructively, at the time of the rape, to be liable as a principal in the second degree.
Correct. The prosecution really wanted to charge her as a principal, not just an accessory.
So, what rule of law did the court apply here? Can you break down the black letter rule and its elements for us?
Sure. The court applied the rule of constructive presence, and it really requires two main elements. First, that the defendant was helping or encouraging the principal, and second, that the defendant was close enough to render aid if needed at the time of the offense.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How on earth did the court apply that element of presence to the aunt who was in the other room?
Well, this is where the legal reasoning gets, let's say, creative. The majority held that the requirement of presence was fulfilled. They argued that because her malevolent, intimidating influence on her niece was present and continued unabated, she was therefore constructively present.
Wait, hold on. Malevolent influence. That sounds like a ghost story, not a legal standard. How does influence equal an ability to render aid?
And that is the absolute crux of the argument. The court effectively substituted psychological presence for the physical ability to aid. Their reasoning was that because the girl was so terrified of the ant's power was in the room, even if her body wasn't.
I have to play devil's advocate here. Does this align with the traditional common law definition? I mean, the ability to render immediate aid. If she's asleep, she can't exactly jump in and help the uncle if the niece fights back.
You are absolutely right to question that. The source material highlights a dissenting justice who argued this stretched way beyond the common law doctrine. The dissent pointed out that constructive presence was designed for lookouts, people standing watch, ready to whistle or shoot.
And the aunt was not standing watch.
Exactly. The aunt was likely asleep. She wasn't available to help at that specific moment, at least not physically.
So the dissent is basically saying that by expanding this, we're blurring the line between accessory and principal entirely. But the majority rules. So what was the court's final conclusion?
The court upheld the conviction. They affirmed her liability as a principal in the second degree, ruling that this lingering psychological dominance was sufficient for constructive presence in this context.
That is a massive expansion. It implies that if you create a bad enough environment, you are present for everything that happens in it. Okay, moving on from presence. I want to talk about what actually counts as help, because sometimes you might be there, but you aren't actually doing anything.
Right. And we call this the mere presence rule. Simply being at the scene of a crime, even if you know it's happening, generally isn't enough for liability. You need an actus reus, an act of aiding.
Can you illustrate that boundary for us between mere presence and aiding? I'm thinking of that visceral example from the text, the one involving the blood.
Oh, United States v. Eberhardt. Yes. This was a protest case against a Vietnam draft. A defendant provided his own blood, drew it from his own arm to be poured on selective service files.
Okay.
Now, he might have just stood by while others actually did the pouring. But the court held that by providing the instrumentality, his own blood, that act constituted aiding.
That's a vivid image. He literally put a piece of himself into the crime. It's hard to argue you're just a bystander when your own blood is staining the files.
Exactly. Even if he stood still during the pouring, the act of donation was the aid.
Now let's flip that. What if I don't give blood? What if I don't do anything at all? What if I just stand there and watch something terrible happen? Is doing nothing ever a crime?
Generally, no. You can watch a crime happen and walk away. But there is a massive exception. Legal duty. And this is where we contrast State v. Walden with Commonwealth v. Raposo.
Walk us through Walden first.
In Walden, a mother watched her child being beaten by another person. She did nothing. The court found her liable as an accomplice because of the parent-child legal duty. Her silence, when she had a legal duty to speak and protect, became the act of encouragement. The law says if you have a duty to intervene, silence is approval.
And what about Raposo?
Raposo is the counterpoint, and it frustrates a lot of law students. A mother failed to intervene to prevent a rape of her child. But in that jurisdiction, at that time, the court refused to count that omission as aiding without a specific statute criminalizing the failure to act.
That is tough to hear, but it underscores the importance of the statute. You always have to ask, is there a legal duty? If yes, silence is a crime. If no, silence is just moral failure.
Precisely.
Let's shift back to the mechanics of help. Suppose I do something to facilitate the crime, but the criminal didn't really need me, like they were going to rob the bank anyway. Do I have to be a but-for cause?
This is a really common misconception. The general rule is no. Your assistance does not need to be a but-for cause.
Really? So I can be an accomplice, even if my help was technically useless?
Well, not useless, but it doesn't have to be essential. The standard is that it's sufficient if the aid facilitated the result, made it easier, or, and this is key, deprived the victim of a single chance of escape.
This brings us to the famous Telegram case, State ex rel, Martin v. Talley. This case feels like a movie script. It's got a feud, a posse, a race against time.
It really is cinematic. It involves the Skelton brothers, a man named Ross, and a judge named Talley who decides to get involved.
All right, let's analyze State ex rel, Martin v. Talley. First, let's get the story straight. What are the legally dispositive facts?
The Skelton brothers were pursuing a man named Ross to kill him. Ross's relatives found out and sent a warning telegram to Ross in the next town, basically telling him to flee. Judge Talley, our defendant, was on the Skelton side. He goes to the telegraph office and sends a second telegram to the operator at the destination, strictly instructing him not to deliver the warning to Ross.
And the operator obeyed him?
The operator obeyed Talley. He didn't deliver the warning. And Ross was killed by the Skelton brothers when they arrived.
And what was the core legal issue?
The issue was causation. Did Judge Talley aid the murder? The defense argued that the Skeltons were heavily armed. Ross was trapped. It was never proven that the warning telegram would have arrived in time to save Ross anyway.
So the argument is no harm, no foul because he was going to die anyway.
Exactly. Maybe he was a dead man walking regardless of the telegram.
So what rule of law did the court apply to that causation question?
The court applied what we call the deprivation of a chance rule. And the elements are, 1, the defendant rendered aid or encouragement here, blocking the warning. 2, the aid deprived the victim of a chance of life they otherwise would have had. And 3, most importantly, it is immaterial whether that aid was the but-for cause of the death.
Okay, now for the court's elemental analysis. How did the court apply that element, the deprivation of a chance, in this case?
The court reasoned that, well, we can never know for sure if Ross would have escaped. Maybe he would have, maybe not. But Talley's interference, his command to the operator, deprived Ross of the chance that the warning might have arrived. Talley put the deceased at a disadvantage.
He removed a potential lifeline.
That removal is the aid.
So by cutting the wire, he cut the chance. And that's enough.
Exactly. You don't have to be the reason they died. You just have to be the reason they had a harder time living.
And what was the court's final conclusion?
Talley is guilty as an accomplice. And specifically, he was a principal in the second degree. The court found that by using the telegraph, he was constructively present at the other end of the line, aiding at the time of the crime by ensuring the victim was vulnerable.
Okay, so we've covered acts, we've covered causation. Now we have to enter the mind, the mens rea. We know you have to intend to help. But what about when the crime changes midstream? Or when it's a complex crime? You called these double-barreled crimes.
Right. And the classic example is a drug deal that suddenly turns into a shooting. You have the drug crime and you have the gun crime. You might have signed up for the drugs, but did you sign up for the gun?
So what's the rule on that?
The general rule is that the accomplice must have a state of mind that extends to the entire crime. So for a double-barrel crime, you need 2 things. 1, intent to do the acts that aid or encourage, and 2, intent that the underlying crime, both parts, be committed.
This brings us to the Supreme Court case Roseman v. United States. This case is huge for understanding when you need to know what's happening.
It's absolutely critical. Roseman really changed the landscape for federal prosecutions because it introduced a very specific timing requirement.
Let's analyze Roseman v. United States. First, what are the legally dispositive facts?
So, Justice Roseman participated in a drug deal. He was there to sell marijuana. But during the transaction, his confederate, the guy he was with, unexpectedly pulls out a gun and fires it. Roseman was then charged with aiding and abetting the federal crime of using or carrying a firearm in connection with a drug trafficking crime.
And what was the core legal issue here?
The issue was all about timing and intent. The government argued that because Roseman stayed in the deal after the gun was fired, he aided the gun crime.
But Roseman's argument was that he didn't even know about the gun until it went off.
Exactly. So the question is, does an accomplice have the requisite intent if they only learn of the gun during the commission of the crime?
What rule of law did the Supreme Court apply? Can you state the rule regarding this idea of advance knowledge?
The court laid down a rule with 2 very specific timing elements. First, The accomplice must have advanced knowledge that a Confederate would use or carry a gun. And second, and this is the kicker, this knowledge has to be acquired at a time when the accomplice still has a realistic opportunity to quit the crime.
Realistic opportunity to quit. That sounds like a safety valve. Now, for the court's elemental analysis. How did the court apply this element? I mean, why isn't it enough to just see the gun and stay?
This is really interesting practical reasoning from the court. They held that if a defendant only sees the gun when it's fired, or maybe moments before, and withdrawing at that point would be dangerous or impossible, they lack the necessary intent. The logic is this. Roseman chose to participate in a drug deal. He did not necessarily choose to participate in an armed drug deal.
So if the gun comes out and I'm stuck in the backseat of the car, I can't exactly tuck and roll out of the vehicle.
Precisely. If he learns about the gun too late to walk away, his continued presence isn't an endorsement of the gun, it's just self-preservation. He hasn't made the choice to aid the gun crime, he's just trapped in it.
That makes a lot of sense. Liability should be based on choice, not just bad luck. So after analyzing those elements, what was the court's final conclusion?
The conviction was vacated. The jury instructions were flawed because they didn't specify that Roseman needed that advanced knowledge with enough time to actually walk away.
This is so interesting. This opportunity to quit creates this really specific window of liability. It essentially says you can be a criminal up to a point, but if your partner escalates and you're stuck, you aren't liable for that escalation.
Correct. It respects the idea that intent is specific. You intended crime A. You did not intend crime B, and you had no chance to stop crime B once you found out about it.
All right, we've covered a massive amount of ground. Common law parties, innocent agents, ants in bed, blood buckets, telegrams, and surprise guns. It feels like a bar exam nightmare.
It definitely can be, but if you have a system, you can beat it.
So let's give the listener that system. If they encounter a parties to crime fact pattern on an exam, what is the step-by-step diagnostic checklist?
Okay, get your pens out. Here's the complicity diagnostic checklist. You follow this order and you won't get lost. Step 1, identify the role. First question you ask, is the defendant the principal in the first degree? Check. Did they perform the act? Or, remember our very first point, did they use an innocent agent? If they used a child or someone mentally incompetent, they are the principal, not an accomplice. Stop there.
Okay, step 1, innocent agent check. What's next?
Step 2, analyze actus reus, the conduct. Did they aid, abet, counsel, or encourage? Check. Remember, mere presence is not enough. Check. Omission is only enough if there is a legal duty. And check. Causation. It does not need to be but for. Look for that loss of a chance from the tally case.
Got it. Then the mental state.
Step 3. Analyze mens rea, the intent. Do they have dual intent? Intent to aid plus intent for the crime to succeed. Check. For complex crimes, like guns and drugs, apply the Roseman rule. Did they have advanced knowledge and a realistic chance to walk away?
And the final step.
Finally, step 4, procedural status. In modern statutes, remember that the principal's fate generally doesn't matter. The accomplice is liable for their own accountability. So if the principal is acquitted, the accomplice can still be convicted.
That is a solid framework. Step 1 is always the one I could see myself forgetting, to check for the innocent agent first.
It's the most common mistake. Always ask, who is the tool?
Before we sign off, I have one last provocative thought for you. The text mentions that some jurisdictions are okay with something called knowing assistance. This idea that if I just know the crime is happening and I help, I'm liable, even if I don't purposefully want it to succeed.
Yes, that's the classic merchant's dilemma.
Right, so why should a merchant, say a gun store owner, who sells a gun knowing 100% it's going to be used for a murder, be less liable than the getaway driver? I mean, the merchant technically aided by providing the weapon, but we often just say, oh, that's just business.
That is the ultimate tension in this entire field. It's the tension between freedom of commerce and crime prevention. If we hold every merchant liable for what their customers might do, or even what they know they will do, commerce could grind to a halt. A taxi driver would have to interrogate every passenger.
But if we don't?
But if we don't, we allow people to profit from tragedy. The law tries to find a middle ground, usually requiring purpose, rather than just knowledge, to protect the neutral merchant. But it's a line written in sand, and it shifts all the time.
And a line we will have to leave right there. Thanks for diving deep with us today.
Always a pleasure.
See you next time.